I got learned my lesson.
How? How have you learned your lesson?
Just the fact that I don't want to end up in jail or anything like that.
Oh, you've learned your lesson. Alcohol in the car while driving? Are you in this country with or without permission?
Without permission.
I don't care if you have Jesus waiting for you. You're not answering my question. The incoming president does not have very much sympathy. Good morning, sir.
Good morning.
You guys have worked out an agreement where they're offering you 3 days. Why would we do this? You had one just dismissed not too long ago.
This is where the judge starts digging deeper. The defendant claims he learned his lesson, but notice the judge isn't buying it so easily. When someone already had a previous DUI dismissed and comes back with another one, the court starts questioning whether that second chance meant anything at all.
Why would we give you another gift?
I got learned my lesson.
How? How have you learned your lesson?
Just the fact that I don't want to end up in jail or anything like that.
Oh, you've learned your lesson. Really?
Here's an important legal detail. PTI stands for Pretrial Intervention, a program that can allow a defendant to avoid a conviction if they follow certain rules. It's basically the system saying, we're giving you a chance to fix things. But when someone reoffends after PTI, judges often take that as proof the warning didn't work.
The thing is that when we are too nice to people, they end up wrapping their car around a pole the following week. You just had one dismissed. Was it due to a PTI?
Yes, it was, Judge.
You didn't learn a damn thing because now you're back with another DWI. And you want me to take this time served so you can go around again? How have you learned any possible thing, Mr. Lara? Tell me.
That house with priors analogy is actually a powerful way to describe criminal records. Each prior offense becomes another brick. The more bricks you stack up, the heavier the consequences become. And in DUI cases, repeat offenses can quickly lead to mandatory jail time and much steeper fines.
What have you done differently from the first DWI to the DWI you have done now to show me that you've learned something? What have you done? I want you to understand one thing, sir, is that you now are building yourself a house with the priors that you have. At some point, that house is going to crack, cave, and your ass is going to fall through. From now on, you will now be looking at a minimum of 30 days in jail. The proverbial slap on the wrist is gone because now, as a matter of fact, with your priors, you're looking at a minimum of 90 days in jail for anything that you pick up from now on. You will also now be required to pay the fines, fees, and surcharges with this case. And I'm going to tell you, if you don't, every $100 that you owe, you will sit in jail for 1 day. You now will have around $4,000 in surcharges that you will be responsible for. And if you don't, there's going to be a heavy, heavy toll to pay. One way or the other, we are going to reach you, Mr. Lara. And if it's kicking and screaming you, dragging you into jail, all we want are our streets to be safe. That's all we want.
Speak up.
Yes, sir.
No more games. Even if you have a sip of alcohol, a sip of wine, you should not get into a car because with your record, you get pulled over. Do you understand me?
Yes, sir.
How much are the fines and surcharges? 3. Is it above a 0.15? What is it?
Yes, sir.
For the current case, it is a 0.092.
It's a 0.09?
Yes.
I want you to understand that you're going to pay a very hefty fine fees. If it's above a 0.15, it's $4,500 in surcharges, not to mention the court cost. Now it's below a 0.15, so you're paying $3,000 on the surcharge. I'm going to require you to pay also the court costs as well. When you pick up a second DWI, it's a $6,000 surcharge, not to mention all the court costs. So Get ready. Not only is it a minimum of 90 days next time, but you're looking at around court costs and fines and fees and around $7,000. How much money have you paid surrounding all this? When all it could have done is one click on your phone, $20. It's a geographical oddity. Don't matter where you want to go with your Uber, $20. Anywhere you want to go. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, there's no coming back. Do you understand? It will go on your record. It's going to be there for the rest of your life. It's even there after you die. And I'm telling you, Ms. Lara, you get pulled over and even have the faintest, funkiest smell of anything, you're going to be right back with us. And I'm going to tell you, I have jurisdiction over you for the next 5 years. Do you understand? You come back, it's not going to go well.
Yes, sir.
Get a clue. Hit a button. How do you plead to the offense? Guilty or not guilty? How much is the court cost?
$3,420.
You will be required to pay $3,420. I will give you time to pay it because we're not here to break your bank. But I want you to understand that we mean business. And the way that we do it is this way. If you don't pay $100, for every $100 that you owe, it is 1 day in jail. So you can imagine on $3,500 how much time you'll be doing. You understand? All right, good luck to you.
Thanks, Chief.
I'm suspending his license for 6 months as well, 180 days. All right, Eddie,
Yes, sir, Judge.
get your boy, man. Christian Martinez Velasquez.
Sí. Yes.
Mr. Martinez Velasquez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 7th, 2024, the officer alerted dispatch about a traffic hazard regarding the defendant's motor vehicle after observing it sway in the moving lane of traffic, impede traffic, when the defendant had the green light, and upon contact with the vehicle, the officer observed the defendant to be asleep in the driver's seat. The defendant's foot was on the brake and the vehicle was on.
Now the situation becomes even more serious. When someone without legal status is booked into jail, it can trigger an immigration detainer, meaning federal immigration authorities may step in. That could turn a short jail stay into months in immigration custody and possibly deportation.
After the officer woke the defendant by banging on the window, he seemed disoriented, and the officer observed glossy, bloodshot eyes, an odor of an alcoholic beverage, and slow movements. The officer observed an open Modelo beer can in the cup holder next to the vehicle.
Alcohol in the car while driving?
Yes, Your Honor. And the defendant admitted to drinking 3 beers and 1 shot before driving. Standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 4 out of 8, 1 leg stand 0 out of 4. The DIC was read and the defendant consented to breath. The results were .087 and .086.
Mr. Martinez Velasquez, I'm going to find that there's probable cause to go forward with your case. Are you a citizen of the United States?
No,
Are you in this country with or without permission?
without permission.
What happens if you go to jail?
Pues ya, saqué tuve un error y
I don't know.
What happens if you go to jail?
Si usted va a la cárcel.
Are you in this country with or without
Es
permission?
como sin permiso.
sin permiso. y-
Without permission.
What happens if you go to jail?
O sea, si usted va a la cárcel.
No sé qué decir, pues tengo mi familia, tengo mi hija.
I don't know what to say. I have my family, I have my daughter.
I don't care if you have Jesus waiting for you. You're not answering my question. What happens if you go to jail?
Pasa si usted va a la cárcel.
I want you to
¿Qué le
think.
pasa? Quiero que piense.
Pues que voy a estar No voy a estar libre, voy a estar en un lugar donde no quiero estar por mis consecuencias.
I wouldn't be free. I would be somewhere I wouldn't want to be because, as a consequence,
You are not in this country with permission.
no está en el país.
If you go to jail,
Si usted va a la cárcel,
immigration sweeps the jail every
cárcel,
couple hours. If they find you in the jail, they will put an immigration detainer on you, and you will be stuck like Chuck in jail until this case is over with. And then you get shipped off to immigration, where you will sit for another 6 to 9 months waiting for them to do whatever they're going to do. The president does not have very much sympathy for you, if you catch my drift. And I'm going to tell you now, the fact that you have an open container, if they allege it in the information, it is a minimum of 5 days in jail to any sentence that you do. And I will tell you, any more than 4 to 6 hours you spend in custody, is very well that you may get an immigration detainer. I am putting conditions on your bond now, and if you violate these conditions, I will, in a moment's notice, put you in jail, and I will not give you another PR bond.
no le daré otra
The reason you got out of jail so quick is we gave you a free bond. It's not going to happen again. Do you understand? First and foremost, you are not to drive. I don't care what's going on in your life. I don't care what you need. I don't care what you have to do. Kids, groceries, Jesus, don't drive. You will be signing an affidavit. This is a promise you're making to me that you're not going to drive. I am also ordering you not to consume alcohol or illegal drugs, and I will randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, you will go to jail. You will not get any more PR bonds. Do you understand?
Correcto, sí.
Yes.
Forewarned is fair warned.
Advertido.
You will not get any warnings from us.
Okay.
We are going to reset your case to give you time to hire a lawyer. So I will have you come up here, swear to us that you're not going to drive. I'll get you to Victoria, where we will have you sign a reset. And after that, we'll send you out here. And when you come back, have a lawyer, sir. Do
Cuando regrese,
not drive.
Okay.
Okay. Catherine Olvera, ma'am, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On March 10th, 2025, at approximately 1 a.m., officers conducted a traffic stop at the 16,000 block of Katy Freeway on a white Lexus for speeding. The officer paced the motor vehicle traveling 85 miles per hour in a 60 miles per hour zone for approximately a quarter mile. The motor vehicle was also failing to maintain a single lane. The officer made contact with the defendant, the driver. The officer observed a strong odor of an alcoholic beverage, slurred speech, red glassy eyes, and the inability to balance. The defendant admitted to having 2 drinks prior to driving the motor vehicle. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The DIC was read and she consented to breath. The results were a .187 and a .185. She was identified by her driver's license.
So any prior WIs and then
No prior to WIs, her license is eligible.
that. All right, Ms. Olvera, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming, I will revoke your bond, put you in jail. No more PR bonds. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him, and he'll tell you if and when you have to come back to court. If I find that you pick up a new case, you're driving without insurance, anything else, then it's not going to go well for you. I'll have you sign a reset with Victoria. We'll have you get with Fleischer for your bond conditions, and then you're free to go. All right?
Judge, with the K, Olivera, amendment.
Ms. Olvera, come up.
Yes, nothing more.
You are Catherine Olvera. Ma'am, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On March 10th, 2025, at approximately 1 a.m., officers conducted a traffic stop at the 16,000 block of Katy Freeway on a white Lexus for speeding. The officer paced the motor vehicle traveling 85 miles per hour in a 60 miles per hour zone for approximately a quarter mile. The motor vehicle was also failing to maintain a single lane. The officer made contact with the defendant, the driver. The officer observed a strong odor of an alcoholic beverage, slurred speech, red glassy eyes, and the inability to balance. The defendant admitted to having 2 drinks prior to driving the motor vehicle. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one leg stand. The DIC was read and she consented to breath. The results were a .187 and a .185. She was identified by her driver's license.
So any prior to WIs and then
No prior to WIs, her license is eligible.
that. All right, Ms. Olvera, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming, I will revoke your bond, put you in jail. No more PR bonds. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him, and he'll tell you if and when you have to come back to court. If I find that you pick up a new case, you're driving without insurance, anything else, then it's not going to go well for you. I'll have you sign a reset with Victoria. We'll have you get with Fleischer for your bond conditions, and then you're free to go. All right?
Judge.
Thanks, Mr. Nolan.
Demisha
You're
Johnson.
appointed on the case?
Yes,
Did you just get appointed to the case?
got a point today, Judge.
Okay.
Judge, we already found PC and did bond condition.
Yeah, I thought we did.
We're just waiting on council for a reset date.
Okay. Yeah, you're good to go. Just, ma'am, don't drive. Above all else in the short life that we have, don't. I don't care what your justification is. If you drive, it's really not going to go well for you. Do you understand? All you got to do is get your Texas driver license, liability insurance, show us that you got it, and then I'm happily take all these conditions off.
Can I ask a question? If I do my occupational license, then could
You
you?
need to call DPS first, because if you've never had a license, that's going to be an issue. So you need to call them first to see what you need to do. Don't just try to apply and start spending 152.
I went there. That's why I have asked you.
Don't just start, I can't give you legal advice. The only thing I would say is go to DPS, call them, and they can tell you what you need to do to actually get your license. Why are you going to pay all this money to get an occupation when you should go get your regular license?
Because on the chart it says that I have to have an occupational for like a amount of time in order to release the license.
I don't know if I would grant you one. I really don't. I'd have to look at a lot of things. First things first, though, is call DPS. This is the number of the driver's license division. Call them at 7 in the morning. Otherwise, you'll never get through. Don't call at 8:01, 9:32. You'll never get through because the phone lines, you have to call it right when they open, which is at 7. Call them and figure out what you need to do to try to get it back. And that's what you need to do first and foremost. Okay?
Demisha Johnson?
You said Kamisha Johnson?
Yeah, is that how you pronounce your name?
Yes, sir.
Yes, Judge. Demisha
You're
Johnson.
appointed on the case?
Yes,
Did you just get appointed to the case?
got a point today, Judge.
Okay.
Judge, we already found PC and did bond condition.
Yeah, I thought we did.
We're just waiting on council for a reset date.
Okay. Yeah, you're good to go. Just, ma'am, don't drive. Above all else in the short life that we have, don't. I don't care what your justification is. If you drive, it's really not going to go well for you. Do you understand? All you got to do is get your Texas driver license, liability insurance, show us that you got it, and then I'm happily take all these conditions off.
Can I ask a question? If I do my occupational license, then could
You
you?
need to call DPS first, because if you've never had a license, that's going to be an issue. So you need to call them first to see what you need to do. Don't just try to apply and start spending 152.
I went there. That's why I have asked you.
Don't just start, I can't give you legal advice. The only thing I would say is go to DPS, call them, and they can tell you what you need to do to actually get your license. Why are you going to pay all this money to get an occupation when you should go get your regular license?
Because on the chart it says that I have to have an occupational for like a amount of time in order to release the license.
I don't know if I would grant you one. I really don't. I'd have to look at a lot of things. First things first, though, is call DPS. This is the number of the driver's license division. Call them at 7 in the morning. Otherwise, you'll never get through. Don't call at 8:01, 9:32. You'll never get through because the phone lines, you have to call it right when they open, which is at 7. call them and figure out what you need to do to try to get it back. And that's what you need to do first and foremost. Okay?
Great. Thank you, Judge. All right.
My name is Judge Fleischer. How are you doing? I have Jonathan Lopez on docket today. It's a violation of bond conditions. After speaking with him and looking at it, it looks like he signed for bond conditions on March 5th, and that was filed on March 5th, and that stated an address. However, another bond condition, an amended bond conditions, was filed on March 10th with that address crossed out and a new one added in. He wasn't aware of that, and that's the address that he went to for this violation of bond conditions. He's here.
If I needed to, this was a case
Yeah.
where we came back for amended Moab. Brad was the attorney on it. He came in, we scratched out the old address. It looks like, based on what I saw, his client had initialed it, Brad had initialed it, and we sustained it. And it looks like as soon as he got out of jail, he went to that address.
He's not aware of those. Let me pull it up.
So you're saying he did?
Yes, Judge. On the amended book, there's his initials on the amended book, as well as the attorney.
I'll advise him. He was stating that he was unaware that that's why he was initialing. I told him I'll address it with him, but it's a presumption that he knows what he's signing. But I did tell him that I will bring it to your attention.
Does he want?
He's just basically saying that he didn't know what address that he was supposed to be prohibited from. He was under the impression that he's still supposed to be prohibited from the 20915 Barrow Street and not Owens. I told him I would address it with you.
Okay.
We could bring him out if you want to.
I don't know. It's up to you. I mean, if you want to, but it looks like he's got a high bond on the felony case, huh?
Yeah.
And he's not made bond on that case, so he's got a high bond on our case as well.
And Your Honor, I think it's actually, so there's two John Lopez on the docket. One's a DPO.
Oh,
Sorry, Your Honor. And I know what case you're talking about too.
oh, I see.
This one is just a misdemeanor. This
I have literally two John
and
Lopez's.
Lopez's. Yes.
You're wrong.
I have Santos.
That's why.
So this one, no, he just has this VPO. I did talk to the state. I understand the concerns. I just wanted to bring this to your attention because he's saying that he was unaware of the change of address.
I told him over and over and over. Can you bring him out? Jonathan Lopez? Santos. Here. Hold on, let me make sure you get the right one. Bottom of 38, yeah. If he tries to tell me that he didn't know, I mean, how many times did we say?
Well, this is the case where the plea was re-entered after the MOAB was amended, so then you advised him and admonished him once more.
Yeah. I told him I would bring it to your attention, Judge, so.
So this is the one where we did, we did the plea on the terroristic threat, right? The terroristic threat, the evading were dismissed. Or two terroristic threats and an evading were dismissed, right?
That wasn't with me, Judge.
Yes, Judge.
Okay, so no, it was just one terroristic threat.
One terroristic
Yeah, it
threat.
was just one. How's jail? Some just don't get it. I mean, I'm truly at a loss. Truly at a loss. When we did the plea, not 6-7 days ago, I told you probably 25 times, don't go back. And now here, you've picked up a violation of a bond condition of protective order. Let's do probable cause because I don't know. You have the right to remain silent. Anything you say can or will be used against you, sir. Please.
On March 12, 2025, in Harris County, Texas, officers were dispatched to a violation of a protective order call. The officer met with the complainant, who stated that she found the defendant in her mother's house while there was an active protective order, including a residency restriction. The officer arrived and found the defendant at the location and confirmed there was a protective order prohibiting the defendant from being at the location.
So it goes back to mom's house.
Yes, sir.
Not the.
Yes, sir. She went back to the residence.
I don't know what we're gonna. I don't know.
I just want to make sure that he knows or that I wasn't there on the plea before. I just seen that the two different filings. He's saying that he didn't know the address.
Problem is that we have
Yeah.
the wrong address,
Right.
so we amended.
So but he was unadmonished about the new address.
And so far as the lawyer even went to the jail to go talk to him,
Okay.
to tell him. So I did,
Okay.
the lawyer did.
Okay. Well, thank you, Judge. I didn't know that.
I don't know if you're going to get out, but let me tell you something, and I want to make this really clear to you, Mr. Lopez, is that now, with what you were charged with, the Texas Constitution does not allow me, but in extremely limited circumstances, this being one of those, to have a hearing to hold you at no bond. Zero bond. This is that type of offense. I don't know if you're going to get out. I don't know if anyone is going to pony up the $5,000 to get you out. If someone does, I'm going to put an ankle monitor on you. If I find that you violate any of the conditions that I'm going to put on you now, I will have a hearing to hold you at no bond. Do you understand? I don't know what it's going to take to get you to hear me, but perhaps that may be it. I don't want you to have any contact with the complaining witness in this case. I don't want you to have any contact with mom. I don't want you to have any contact with dad. I don't want you to have any weapons. I don't want you to go within 1,000 feet of where they live, or where they work, and the address listed in this order for protection. Do you understand?
Can I have the address, sir? The correct address.
We will give it to you. Prior to me, I'm going to tell you this now, Ms. Strong, that prior to me accepting anything, any kind of plea bargain in this case, I would like to have a TRAS done to see how we go forward. Because I'm going to tell you now that every time that something, and
I understand, Judge.
okay, all right,
Absolutely.
okay. So we need him to sign conditions real quick, and then we'll give him a copy of the MOA right here, and then he can go back.
Thank you.
Sure, and I'm going to find. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 31st, 2025, the officer observed the defendant's vehicle run a red signal light at the 3400 block of Live Oak Street in Harris County, Texas. The officer further observed the vehicle completely failed to stop at a red signal light and activated his emergency equipment. And the officer made contact with the defendant, who was observed to be behind the driver's seat of the vehicle. And the defendant stated that he does not have his identification card with him. And the defendant gave a fictitious name of Fisher Leroy, with date of birth January 1st, 2006. The officer ran the name through NCIC and found a DPS picture that does not remotely resemble the defendant. The defendant was asked if he was given the correct information, and the officer walked back to his patrol vehicle to double check, and the officer then observed the defendant exit despite giving him orders to stop. The officer ran after the defendant and observed the defendant get into another vehicle, the passenger side. The other vehicle drove away, and the officer gave the last direction of travel over the radio, but was not able to locate the vehicle. The officer walked back to the defendant's vehicle, secured it, and conducted an inventory check, finding a debit card inside with the name Kendrick Davis. The officer ran the name through NCIC and found a hit with a date of birth of 2/10/2003 with multiple Class C warrants, and ran a driver's license check with the defendant's picture and with date of birth. The DPS picture matched the defendant, and he was able to positively ID. And that's it, Your Honor.
So I'm going to find that there's probable cause to go forward on both of your cases. The reason I'm bringing you out now is because there's no bond that's set on your cases, and we have to set you a bond. One of the things that I use to determine on what to set a bond is how dangerous you are, because I've never met you before. I don't know you, and All I know is that you've got a birthday in 5 days. So he's on bond for an aggravated robbery now, right?
Yes, Judge. It's my understanding, I think it was a 2B, it looks like. I don't believe bond conditions and everything were put in place until a few days ago.
Okay. So the charging instrument was filed November 13th of 2024. I think that you may well be right. In that case, it says here,
Listen carefully to what the judge is saying here. In bail decisions, courts look at three main things: the seriousness of the crime, the risk that the defendant might flee, and the danger to the community. Based on the robbery allegations and the high-speed chase, the judge clearly believes public safety has to come first.
A Kendrick Richard Davis hereinafter saw the defendant heretofore on or about August 12th, 2024 did then and while in the course of committing a theft of property owned by yada 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 with intent to obtain and maintain control, intentionally and knowingly caused bodily injury to the complaining witness by using and exhibiting a deadly weapon, namely a firearm. Complainant McSweeney advised that defendant Davis proceeded to pull a pistol from his waistband and pistol whip him with it multiple times on his head and face area, causing multiple cuts and bruises to his head and face area. As he proceeded to fall down on the ground, he continued to strike him in the head and face area with a closed fist and then stomp on his face with his foot. Complainant McSweeney stated that he was in fear for his life and felt severe head pain as a result of the assault. I see that he has also picked up an evading arrest in a motor vehicle the day after our two cases. How? Oh, I guess that's how they caught up to him, right?
They must have. They found him, and that's when they arrested him on that, and then he got picked up on me, I believe.
Okay, so what happened in that case? Is he like driving 100 miles an hour? Is he just...
The officer observed the defendant conduct an improper turn and failed to turn into the correct designated lane. They activated their lights and sirens, and the defendant evaded at speeds of 90 to 115 miles per hour for 3.5 miles on the highways and multiple residential and business streets.
Okay. I think that you are an extreme danger to our public, and I'm going to do everything in my power to protect our public. The first thing I'm going to do is I'm going to order you not to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what is going on in your life. I don't care if there's a burning building. You have to say 50 kittens. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months jail and a $500 fine every time you get into a car and drive. Do you understand?
Yes, sir.
I'm also putting in this affidavit that you're not supposed to be in possession of any weapons as well. If I find that you have a weapon, because I don't know if you're going to get out or not, and because these cases, because of the nature of the aggravated robbery, because of the nature of this one, I'm making his bonds high. You know, I'm going to set them at $20,000 each.
So can I make an argument?
Yes,
Okay.
absolutely.
You,
I don't want to get ahead of myself, please. Yes.
So I was appointed to Mr. Davis this morning. I was able to talk to him a little bit in the holdover. We are requesting PR bonds for both of the cases. He's 22 years old. 21 years old. He's lived in Houston his whole life. He has a lot of family in Houston. His grandparents, mom, daughter, and siblings. Prior to being in custody, he was working at Builders First Source for around a month. Mr. Davis also lives with his grandfather who has cancer. Mr. Davis is his caretaker, is my understanding. Mr. Davis has no savings and was found to be indigent by the court, so we are requesting a PR bond.
I think that he is an absolute, just a complete danger to our public. I can't possibly give him a PR bond due to the nature of both of the charges that you are facing now. I think that you're a flight risk. You've done everything in your power to evade capture. You've produced false names. So I find by clear and convincing evidence that you're an extreme flight risk. You're a danger to our community. And I'm going to set your bonds each at $20,000. I don't know if you're going to be able to post bonds, but if you do, I'm going to order you under house arrest if you do get out. And I'm going to order you to obtain a GPS monitor on your ankle. like I said, you will be signing an affidavit with me today, promising me you're not to be in possession of any weapons and not to drive any vehicle whatsoever for any reason. If you do, I can have a contempt hearing. Do you understand?
Yes, sir.
The felonies are set for April 7th. I don't like to set them out too far just in case. If you want to, we can do up to 30 days. It's up to you.
That's perfect.
And then we'll come back. I don't know. We'll see what circumstances have changed, and then we'll go from there and just keep us in the loop.
Okay, thank you.
All right. I need you to sign this for me. I need him to sign bond conditions with Felicia, and then after that, just